These trust accounts are highly regulated. They have to be monitored by audit. If the division decides they want to see the records, those records must be turned over immediately to the division so they can audit. And if they want to do a serious audit, they can even hire a CPA to come in at the broker's expense to try to figure out what is happening in that trust account. The account has to say real estate trust account on the account, and it has to say real estate trust account on the checks that are used and also on the deposit slips as well. And it's supposed to be a non-interest bearing account. That's why a broker could have another account that did bear interest, but we already talked about that. It has to be in a bank in Utah, or it could be a credit union, savings loan, or other approved depository, but it must be in the state of Utah. And the principal broker can have as many trust accounts as they want, but they cannot have any secret trust accounts. The division has to know about every single trust account that's out there. What the trust account is trying to do is to prevent something called commingling. Commingling is where the broker mixes his money with monies that come in from buyers or, rare cases, perhaps sellers. When that money is mixed with the broker's money, it's called commingling, and that's a crime. That's a crime in Utah. In our state, brokers can have up to $500 of their own money in that account just to keep the account open. But anything beyond that is going to be commingling. Deposits must be made in the trust account in an appropriate manner and with expediency. Now, the state requires that all earnest monies must be deposited within 3 days of receipt of the earnest money. 3 days. However, there's a provision in that rule that says, or as otherwise agreed to between the parties. Well, the or as otherwise agreed to between the parties is in the state-approved real estate purchase contract, where you can check a box and say that you're going to have 4 days, or you can check a box and says that, well, I'm going to get the earnest money sometime in the future, and then I have 4 days after that to get the money into the trust account. So the state law still says 3 days, or as after receipt, or as otherwise agreed to between the parties. But if you're using state-approved form, which you probably will be, the or otherwise agreed to between the parties would rule because of the provision in the regulation. If you're taking earnest money in the form of a promissory note, then that note has to be kept by the broker and kept in their file. There's a long process involved with getting money out of the trust account. Obviously, the best way is, and the quickest and shortest, is to close the transaction. On the settlement sheets, the earnest money is usually credited for the buyer's benefit, but then it's also debited against the broker's commission. So what happens is the money mysteriously morphs into broker's money at that point. And so he can take the money out because he has the settlement sheets from the title company. A conventional real estate broker who has both sales and management activities in their office may use their regular trust account for their property management activities until the number of accounts that they are managing exceed 6. That would be 7. 7, or exceeding 6, would require a conventional real estate broker to have a separate property management account for their management activities. Utah does not require their brokers to be bonded. The reason why is because in Utah, we have the Real Estate Recovery Fund. The Real Estate Recovery Fund is a pool of money that when you apply for a license and when you renew your license, little bits of money are taken out of that license fee and put into the recovery fund. By law, the recovery fund must have, at the beginning of any fiscal year, a minimum of $100,000. The purpose of this fund is to reimburse the public for harm caused by dishonest licensees, and also to provide revenue for research and education in the real estate field. In addition to little bits of money that come out of your license fees that go into the recovery fund, all fines that are levied by the Real Estate Commission, those monies go into the recovery fund as well. So if it's a $500, a $5,000, a $25,000 fine, that goes in the recovery fund as well.